Now call the second case on the docket, 118673, 118674, and 118675, State of Kansas versus Kevin Coleman. Counsel.
May it please the court, Anna Upinen, Assistant County Attorney on behalf of the state of Kansas. Just to give you a brief factual background of the case, Mr. Coleman was on probation for 3 separate cases, one from 2013, 2014, and 2015. Each of those cases, he was placed on probation by virtue of a dispositional departure. In January 2017, the state filed a motion to revoke probation in all of those cases with the sole allegation that Mr. Coleman failed to report to a supervising officer. In July of 2017, there was statutory change in 223716. They added subsection C9B, which allowed for the court to bypass the graduated sanctions and allow remand of somebody on probation if they had been placed on probation by virtue of a dispositional departure.
Counsel, it sounds like you might be moving into the merits, and before you did, I just wanted to be sure you didn't want to reserve rebuttal time.
I apologize, Your Honor. Yes, I was asking for 5 minutes of rebuttal.
5 minutes of rebuttal, okay?
Did you want me to continue with the history?
Yes, yes.
Okay. At the probation violation hearing, state argued for remand due to Mr. Coleman's continued failure to report. The defense counsel asked that the court impose an intermediate sanction, saying that the statutory amendment did not apply, was not retroactive to Mr. Coleman. Mr. Coleman himself just asked to have a local sanction and then be unsuccessfully discharged. The court remanded Mr. Coleman, finding him not amenable to probation because he did not want to report, and remanded him due to the statutory change. On appeal, there was a split decision. The Court of Appeals, the majority relied on States v. Kurtz, held that the district court erred in applying the new statutory subsection, and said that the district court was limited to applying the law that was in effect at the time the probation violation occurred. The dissenting opinion said that the majority was putting too much weight on Kurtz and that there was nothing in the statute that prevented application of the entire section, including C9B, due to the retroactive language in C12. To that effect, the argument of the state today is that the Court of Appeal erred in finding that the retroactivity language in section C12 precluded the district court from applying the statutory subsection of C9B. The Court of Appeals noted that the state did not put into its brief that the probation violation was a continuing violation. However, argument to the district court and inherent within the state's argument was that this was a continuing violation. There was only one violation that was listed in the motion to revoke that was filed in January of 2017, and that violation continued until the probation violation occurred, and Mr. Coleman's arrest occurred in the fall of 2017. And the state's argument would be that that does allow the court to go ahead and pull through the retroactivity language.
Let's assume it's retroactive, that was the legislative intent. How do you get around ex post facto?
If you look at the case law where they, at least when you looked at the initial House bill changes that brought about the 2237-16 in 2013 and 14, case law at that time said as long as the defendant had knowledge of what the requirements to be placed on probation were, that then having subsequent changes and amendments to the probationary statute did not violate the ex post facto clause. and that would be the state's argument here, is the defendant was aware of what his requirements would be to be placed on probation at the time of sentencing.
So let's say that's correct. It's retrospectively they're applying this amendment. Then there's a certain a second point that you have to show. Would this disadvantage or be a punishment? The amendment, applying the amendment. What would you say to that?
Probation from this court has always been an act of grace, so is it I don't see that as a punishment. When it comes down to it, the requirements of the defendant are to comply with the probation. He didn't. The court has within its purview what has been set forth by it from legislation, which is to be able, when the defendant violates, of what the sanctions they can impose. So no, I don't see that as punishment.
So, okay, although we have some U.S. Supreme Court's decisions that are talking about if something is a benefit for the defendant, and then there is an amendment made which is retroactive, and it takes that away from that particular defendant, that could be considered as a disadvantage or a punishment. What would you say to some Supreme Court holdings that have dealt with this?
The case law has made it clear, like I said, that this does not violate the ex post facto. I understand where you're going through, and case law does go through and make that distinguishment. The violation, however, what the court imposes on that's not seen as a punishment. When it comes down to it, that's just the violation has occurred, therefore the court is acting accordingly.
Other than the general cases that talk about probation as an act of grace, which of course we all acknowledge that those cases are out there, what's your best authority that a change like this, midstream for a defendant, is not punishment or not a judgment?
I'm sorry, change like what?
What's your best authority? A change like this midstream for a defendant?
When I was going through materials last night, and unfortunately I didn't bring all of those with me, a lot of it where I was looking at would be just the initial enactment and changes in 2237-16 when that came out in 2013, and then the amendment in 2014 allowing for the retroactivity aspect of this to, regardless of when somebody was sentenced, this is what statutorily is allowed. And that's really...
The question is ex post facto, so that looks at whether a statute is unconstitutional rather than just what the statute says. So I'm trying to get behind the statutory language and ask you, beyond just reciting the kind of boilerplate that probation is an act of grace, what supports you on the ex post facto position you've just taken with my colleague?
And that was a lot of what this court, the Court of Appeals, has looked at when they were looking again at that initial statutory revision in 2013, and whether or not that was a potential ex post facto, especially when it came about in 2014, when they said retroactively this is applicable regardless of, as long as you were sentenced after July of 2013. And that has been the standard that has been applied, that was not an ex post facto violation. The defense counsel and the Court of Appeals, as I said, relied heavily on Kurtz. Some of that essentially being that the law in effect at the time that the probation violation occurred is the law that would be applicable to the defendant at the time.
Isn't Kurtz, when we're looking at ex post facto, isn't distinguishable from what we have here? if we consider an ex post facto, that didn't come up in Kurtz. And also what Kurtz dealt with, a probationer was trying to get the benefit of the sanctions.
That is correct.
So Kurtz is somewhat distinguishable when we're looking at ex post facto. Wouldn't you agree?
As far as ex post facto considerations, yes. Was that, however, what the Court of Appeals relied on? Yes.
Yes. Okay. And seeing, I'm sure you're probably relying on what the dissent and what Judge Malone was talking about, retroactive, how you can apply the amendment. And would you agree with that? He was correct as far as what your argument is saying, how it could be applied.
It was a very broad interpretation.
No. I mean, as far as I think you're on the same page with Judge Malone in talking about how the amendment can be applied retroactive, but neither the court there, Coleman, didn't deal with the ex post facto. Would you agree?
That is correct. That was
They
never
avoided
raised.
that. Okay. And so if we just looking at the ex post facto, Kurtz really doesn't help you because Kurtz didn't deal with ex post facto. And when you're dealing with a situation where Kurtz, the probationer, was trying to get a benefit of the sanctions, but he didn't get a benefit because his situation occurred before the enactment of the sanctions.
Kurtz is not probably the saving grace for ex post facto. I'll agree with that. That also wasn't the argument that was essentially delved into by the Court of Appeals. Their reliance was on how Kurtz essentially showed that we need to go with what is the law in effect on the day, and they were saying the probation violation occurred in January of 2017. At that point, that was prior to allowing us to do the dispositional departure. Court of Appeals really didn't get into the ex post facto.
And see, the
part
ex
of
post
it.
facto, some of the cases, especially United States Supreme Court cases, they're saying that we look at when the offense was committed, okay? And we look at the offense committed, and if there was a benefit for that particular defendant or probationary, that if there was a benefit for him, then if you make an amendment and take away that benefit or make it more onerous, okay, then that could be looked at as being ex post facto. So they're not looking at the time of the probation violation. They're looking at the time of the defendant's when the offense has occurred, and that makes a difference. Wouldn't you agree?
Does that make a difference? Certainly in this situation. That frankly, if that would be the case, he has 3 separate cases. We would need to go back and evaluate when did each of those occur, and then what portion of the probation violation statute would be applicable to them. It's very easy to say that 2013 may not even be applicable to 2237-16 as we know it today. That's not, however, how the court has instructed us to operate. The court has instructed to operate that this does act retroactively. So where this is a more particular issue in Mr. Coleman's case is, do we look at the date that the probation, motion to revoke probation was filed in January of 2017, and that is the statute that we need to follow, or do we look at what was the inherent nature of this probation violation, which is between January of 2017 and November 2017, he had a continued violation. If we're able to do that, does that then goes beyond what that July 1st statutory change would be, and then that would allow us to use the C9B because it is considered retroactive. If the court is not going to do that, then then fine, we look at the law that's in place at the time that the probation violation was filed. But it's still, that has been the case law that we are to follow, is 2237-16 as we know it today is not in violation of ex post facto, and this is how we operate with probation violation.
I understand.
That doesn't answer your question, though.
No, I'm just saying, I understand if you look at the plain reading of the statute, and what Judge Malone said in his dissent, yes, you could treat this as being retroactive. It's retrospectively and based upon the law, as is said in the statute and in plain reading. I think that's a correct statement. But if you take it a step further and look at ex post facto, then it may not survive under ex post facto analysis.
And that is a possibility. However, that was not the argument that was presented or that was brought before the Court of Appeals.
Appellant, I believe, made an alternative argument, saying that if you didn't agree with the argument saying that you shouldn't, the plain reading didn't allow you to use the amendment. I think there was an alternative argument that the appellant made and mentioned an ex post facto, that it would be an ex post facto violation. I mean, if I'm incorrect.
That may very well be correct. However, I've read the opinion several times. I don't recall anything within the opinion dealing with the ex post facto part of it. So I apologize, sir. I'm probably not as prepared to address that as I should be.
Okay.
Other questions? Okay. Thank you, counsel.
Thank you.
May it please the court. Kai Mann on behalf of the appellee in this particular case, Mr. Coleman. Just want to start out with a few things about what was argued below. First off, the appellant Mr. Coleman absolutely argued that this is an ex post facto version below. Page 6 of the brief, the legislature has not clearly indicated that subsection C9B operates retroactively. Also, retroactive application of subsection C9B would violate the ban on ex post facto laws. And then we go into an ex post facto analysis in which, we explain how this is an ex post facto violation. Furthermore, regarding the continuing violation.
I'm just trying to figure out what you cited there.
Oh,
It looks like the only thing you cited was the Constitution.
No, that was just the heading. We go into page 6, 7, 8,
Right.
where we discuss ex post facto violation. And I would also assert that the ex post facto violation, while not the basis of the Court of Appeals holding below, on pages 3 and 4, they discuss ex post facto. They find that this amendment has been applied to Mr. Coleman after his act of failing to report, and they also found that the amendment was enacted with punishment in mind. Now, they did not decide the case on that basis. I believe that the court engaged in constitutional avoidance and ruled on Kurtz to find that this, to base their ruling in. But there is ex post facto discussion throughout this entire case. This is not a new issue in this case. And again, I believe that this is an ex post facto case. Well, first off, I also believe that the legislature did not clearly make this retroactivity, or did not clearly make the dispositional departure exception run retroactively. The retroactivity provision that the state is relying on was in the statute 3 years prior to this dispositional departure exception being inserted. And so therefore, this retroactivity provision doesn't tell us anything.
But they did add 9B at the same time that was there and said this section.
No, they actually... sorry.
Yeah, no, that's fine.
Yeah,
That's fine.
I will
where
agree.
am I wrong?
Yeah, I will agree that the legislature did add Section 9B and leave in that zombie retroactivity provision. But if you read the plain language of the retroactivity provision, the violation sanctions provided in this subsection shall apply. So why does that not simply mean the benefit conferred by C1 with the actual sanctions themselves to apply? Because at the time they did this in 2013, the sanctions were brand new. They add in this retroactivity provision to tell the district courts, no, we're serious. You can't keep on sending people to prison on their first section. You have to go through the violation sanctions. Revocation and remand is not a sanction. It is the end result. So therefore, that just goes to the clarity, whether or not you believe me that Section C1 is the only thing that's truly retroactive or not, this still strikes at the clarity that is just plainly missing to find that this substantive provision to run retroactively. And therefore, even before we get to retroactivity provisions, we have clear problems of trying to figure out what the legislature did in this case. That provision still survives, even though the statute has been amended many, many times to the point to where currently the graduated sanctions are radically different now, and yet that provision persists. So essentially, I think that this retroactivity provision tells us absolutely nothing about what the legislature was thinking in 2017.
If subsection 12 violates the Constitution, what's the remedy? Isn't it to declare that to be unconstitutional? I'm just wondering about the collateral consequences of that.
Now, I think, I'm not sure if it's necessarily subsection C12 that violates the Constitution, because again, if this is just going to the benefit of the probation sanctions, then we can always run that retroactively. You can always make it easier for folks.
Well, that would be to make a conclusion
Right.
based on statutory interpretation.
Right, but what I do think, though, is that you cannot use C12 to apply exceptions to the graduated sanctions to revoke somebody after the act that would have
That's a
supplied the
statutory
revocation.
interpretation argument, right?
Yes, but I also think that, the main considerations underlying this are still ex post facto and trying to avoid the ex post facto problem. Because to me, I think this ex post facto problem is fairly obvious in this case. As this court said in Barnhart, or Bernhardt, there are two provisions that make an ex post facto law. One, the law must be retrospective, applying to events occurring before its enactment. Here, I also agree with the Court of Appeals that the probation violation in this case occurred no later than January 19th, 2017. I also took a look at the state sentencing. I know the state noted that Mr. Coleman had not come back in after that violation, but there is no argument about this being a continuing violation. And I think that would also strike to the difference between failure to report at a specific time, at a specific place, to a specific person, to absconding. Now, I think had the state maybe alleges us absconding later, we wouldn't be here. But we're in a position where the only violation we have is alleged to have occurred no later than January 17th, 2017. And so therefore, I think, this continuing, there's no way can this be said that he violated, that there's a, that there's a violation of parole that's been proven or stipulated to beyond the date that this goes into effect.
I just want to make sure I
Yes.
understand some of what you said in response to my colleague. So you're saying it's fine to apply subsection 12 as long as it advantages a defendant.
Correct.
That is not a EPF problem,
Right.
obviously, because an advantage doesn't raise that specter. But when it is interpreted to disadvantage a defendant, there's an EPF problem. So the entire subsection would not have to be stricken as unconstitutional. It can be constitutionally applied in certain circumstances.
Yes.
Okay.
Yes. That is much more eloquent than I could have said that.
Would the easier way to do that be to simply interpret or construe the statute in such a way that it's constitutional? As opposed to saying the statute is unconstitutional, either in its entirety or in part.
Right. It would be easier to construe it constitutionally, and ultimately, I believe that's what the Court of Appeals did in this case, because the ex post facto bones and scaffolding are there, but then we get into this discussion of Kurtz and is decided on that case, and that's also my main point of contention with Judge Malone's dissent, is that he just never engages with the ex post facto problem, even though the majority did hint that, hey, even if you're right here, we have an ex post facto problem. Just returning back to ex post facto, the first must be retrospective, and the second provision, it must alter the definition of criminal conduct or increase the penalty by which a crime is punished. However, this court, also when discussing this in Bernhardt, also stated that the crucial question in evaluating an ex post facto claim is whether the new law changes the legal consequences of acts completed before its effective date. And I think that's squarely where we're at in this case, with the violation that occurred no later than January 17th, 2017, being revoked based on a provision that came into effect on July 1st, 2017. So regardless, even if this is clear, which again, for the purposes of this argument right now, I'll maybe grant, but overall, I do not believe it's clear at all that the legislature intended for C9B to run retroactively. But even if that's the case, we have a clear retroactivity or a clear ex post facto problem.
What's the remedy here for acts? Is it that in similarly situated defendants such as Mr. Coleman, any act that took place before July 1st, 2017, the intermediate sanctions are still applicable?
Yes.
And that would be for anyone similarly situated, but then any act after July 1st, 2017, the new statute would be applied.
Yes. Any person who had their probation revoked due to their original probation being given as a result of dispositional departure, that exception.
Prior to.
Right. Yes. That exception cannot be invoked for those probationers prior to July 1st, 2017.
Who committed their crimes prior to that, or their probation violations? Which are you relying upon?
Yeah, it's.
I think that's important.
No, it is important, and in this case, regardless of whether it's probation violation or crime, Mr. Coleman gets the benefit. I would personally run this from the date of the crime of commission. The general rule is always that the punishment and provision is set at the time the crime is committed. I don't see why we need to have a special rule for probationers if this would allow probationers to know exactly the metes and bounds of their probation and of those exceptions at the time of sentencing when the probation is accepted. I feel like anything else has the potential to either pull a rug out from underneath and unnecessarily complicate the process.
Okay, so just, again, I want to make sure I understand your argument. Doesn't affect your client in this case.
Mm-hmm.
You think the best rule is that the date that should control is the date of the crime.
Yes.
But you acknowledge that the 3 dates in issue before the court in this and other cases are the date of the crime, the date of the probation violation, date of the crime, date of the sentencing for the crime. I think that's Judge Atchison's view, and then the date of the probation violation. Okay,
Yes.
thank you.
Saying I have no more planned presentation unless, but I'm more than happy to answer questions.
Any other questions? Thank you.
Thank you.
I think the state has no choice but to concede that the better practice in this would have been to file an amended motion to revoke probation after the July 1st date. That would have eliminated this argument together. That would have firmly put us within the confines of
Say that again. What's your point? That the probation revocation should have been filed post July 1st, 2017.
Had the state filed an amended motion to revoke probation after July 1st, that would eliminate this. The allegation would have been the same. His allegation still was that he was not reporting. But that would have eliminated this issue from the state's perspective, firmly put us within the new statute. Because if you look at case law, the greatest argument essentially against the state at this point is the defendant needs to be put on notice. That would have been, eliminated any argument. He would have essentially been put on notice through that amended motion. However, the allegation was the same. The better practice would have been for the court to make the specific findings. Case law shows that as well. If you look at some of the issues where we are bypassing or are able to bypass the graduated sanctions, the court didn't do that. However, the court did follow what was allowed to it by statute, which was applying C9B, which allowed her to remand this person. The violation was the same from the entire time. He failed to report when it was first reported, January of 2017. Testimony to the court was he never reported after this. He had a few phone calls to his probation officer, but he never presented himself. He never reported. It was the same continuing violation that occurred.
What's your response to defense argument that subsection 12 talks only about violation sanctions, and subsection 9 is actually an exception from the sanctions? It's not the sanctions. So, as I understand it, the argument is even if subsection 12 is a retroactivity provision, it doesn't scoop up subsection 9.
The exception within the violation sanctions still should all be read within the thing. If we're going to apply sanctions retroactively.
Well, how is revocation? I guess that's the question. Is the revocation here part of what subsection 12 is talking about when it talks about the violation sanctions provided in this subsection?
That would be the state's perspective. I mean, if you're looking at a graduated sanction, you have your progression of, whatever the local sanctions are. We don't do the...
Because what happened here is he didn't get the benefit of the violation sanctions provided in this subsection.
He'd had the benefit of those prior. This was not his first time back before the court.
But in this particular case, he did not get the benefit that was provided by the graduated sanctions provided for in the subsection. All he got was revocation.
And those exceptions to the sanctions should still be included within that. If we're going to look at the statute, we need to look at it as an entirety. Section C12 says that it's, pertains to this entire subsection. How can you distinguish that out if we're going to apply these graduated sanctions? Those rules are inherently included, or those exceptions are inherently included within that section. It's the state's perspective on that. Were there any further questions? Thank you.
Thank you, counsel. The court will take this matter under advisement.